May it please the Court, I'm Joshua Gordon. I represent Martha Philbrick, Myra Elshout, and Leonard Thomas. The trust here is logically at odds with itself. On the one hand, it gets rid of assets to qualify for Medicaid, and on the other hand, it allows control of property for enjoyment in old age. It seeks to give away, and it seeks to keep. Attorney Philbrick said he created hundreds of these, and I'm sure that's true, but most people in this situation, they set up their trust, continue living in their home, and when the time comes, qualify for Medicaid. What distinguishes this case, what brings it here, is not only 60 acres of farmland on Great Bay, but more important, Evelyn Thomas, the creator of the trust, didn't leave things alone. She continued to exercise control again and again and again over property she purported to disclaim.
Are those issues preserved, Mr. Gordon?
I believe they are.
And where would we find that?
In the trial court, the Attorney Rizzo preserved a number of issues in his closing. In the initial petition to set aside the conveyances, the equality clause is preserved, as it was discussed during Attorney Philbrick's testimony during trial as well.
If it turns out that those issues, those technical issues relative to who can do what to the trust are not preserved, then we get farther into the problem in terms of undue influence and those sorts of questions. Fair to say?
Say it again?
If the procedural issues, or who can do what to the trust, those issues are not preserved, then the only thing we're really looking at is the trial court's determination that she was competent and there was no undue influence.
Competence and undue influence are not, I didn't brief the issues, Your Honor, and they're waived.
Oh, all right.
Those issues are waived.
So the only thing you're relying upon then are the technical issues.
Okay.
Counsel, can I go back? Because I'm troubled by the very same thing. It's unusual, it seems unusual, that the trial judge would issue a multi-page order and not address the issues you're appealing. Seemed kind of strange. Then I looked at the request for findings and rulings that were submitted, I guess not by you, but by trial counsel. And Martha Philbrick et al. Requested the court make the following rulings of law. And as I read them, not a single one of those relates to the issues you're bringing to us. The trial court didn't talk about them, and suddenly we're reviewing what you didn't ask for and what the judge didn't rule upon. That strikes me as, what are we doing in this picture? Well, what am I missing?
Well, they are clearly not in the findings and rulings.
Not even in the request for findings.
Not in the request for findings and rulings. But Attorney Rizzo did address them in his closing. He didn't do it in with the citations that I provided, and he didn't do it in great detail. But he mentioned the issue.
You think that's what the law intends? Being a trial judge is a hard job. And it's hard enough when people tell you what they're looking for, as opposed to when they're saying, well, why don't you speculate what it is we want? I mean, Attorney Rizzo made very specific requests. Not one of them related to these two issues. So if you were the trial judge, wouldn't you be thinking, why is the Supreme Court reviewing that which I wasn't asked to review? No one asked me to make findings on that or rulings. So how do they get to jump over me? I don't get that piece.
Well, the law, the preservation law, as I read it, is if the trial judge had an opportunity to rule. It doesn't.
You think he had an opportunity to rule here?
I think he had an opportunity to rule.
Because he raised them in oral argument. Is that what you're saying?
He raised them in oral closing argument.
Did the other side respond to that argument?
I think so.
So you don't know if they responded to these same issues?
I think they did. I think the closing is all of 7 or 8 pages long, the two of them together. The fourth volume of the transcript, and I think they're there. They're barely there, to be sure, but they're there.
No, I understand. I'm not being critical. You weren't trial counsel. I'm not being critical of trial counsel. I'm just trying to figure it out because I have a job to do here. When this decision came down adverse, did Mr. Rizzo file a motion to reconsider, saying, Judge, you remember my closing argument? I gave you 2 issues. You didn't even talk about them.
The issues are either not in the motion to reconsider or are nominally there.
Now, wouldn't you agree with me? I mean, just practically sensibly, the trial judge didn't know this was happening. You don't put it, not you personally. The lawyer doesn't put it in his request. He loses. He doesn't go back and say, Judge, we're not even worried about undue influence. We're worried about who can do what with this trust. I made the argument. You obviously didn't hear it sufficiently. Come on, you got to make a ruling. Mr. Rizzo didn't do that. And then, no fault of yours, you arrive at the case, and you're up here appealing issues that the trial court did not rule on and which trial counsel did not ask the court to rule on in a motion to reconsider. It seems to me that's hiding the ball in the trial court. Don't you think it is?
Well, I understand the concern, for sure, and I may repeat that if the law is that whether the trial court had an opportunity, if that is the nominal opportunity to rule on the issues, that much I believe was done.
So let's assume for the sake of the discussion then that there is sufficient preservation, and perhaps you could talk about the two issues you think we should consider.
Well, I want to talk about the equal treatment clause. It says the intent of the donor is to make an equal distribution to her children as nearly as possible. My brother says it doesn't count because it's under the heading residue, but the trust is very specific that those headings are not to be used in interpretation, and therefore the equal treatment clause applies generally. Evelyn, as creator of the trust, she could set it up as unequally as she liked, but all others following that, whether trustees, donors, or donees of the power of appointment, or this court in construing the trust, is bound by the equality clause. And I want to turn to the two specific actions she took. First was...
Let me ask you this first. Under Clause 6, it says that the trustee and each one of them singly shall have the following powers. And then it goes on to list 19 different powers. Why didn't that give her the authority to execute deeds, etc.? Why didn't it give her the authority to do what she did?
Attorney Ferber in his testimony was very clear that the purpose of this trust is to not hide. I don't mean that in any wrong sense, but to keep assets away from recognition by the government for Medicaid purposes. And other trustees can, he said this in his testimony, other trustees can act singly. But if Evelyn were to act singly, that would be such an amount of control as to approach fee simple that it would defeat the purposes of the Medicaid eligibility.
Maybe it wouldn't qualify for Medicare after that, but the language of the trust seems to give her that power.
And perhaps it does, but it would also, when you do something like that, it defeats the trust, and that's the problem.
But I don't understand why that's a problem. I mean, if she wanted to convey all this stuff and had the power to do it, if she's defeated the purpose of her own trust, you know, she's going to have a problem when it comes to Medicaid.
Maybe so, Your Honor. I want to focus on a different aspect of the trust, this equal treatment, because when she conveyed Lot B out to Alan, she was wearing her trustee hat at that time, and it's plainly unequal to give a half of the assets to 1/4 of the children, and so as trustee, she didn't comply with the equal clause. So regardless of whether she did it correctly, singularly, or not, it violates the equal treatment clause.
Counsel, can I ask you, is the mother still alive?
Alive, but not mentally with us.
This is my question too. How can we resolve an issue over the trust she created, and she's not a party here? I mean, how do we do that? She's not even a player here. It seems like there's an elephant in the room. I mean, when does she get to weigh in on what it means and what it does?
Well, it's no different really than a will problem, you know, if the person's unavailable. But the plaintiffs are not contesting the trust. They would like to have the trust complied with, as it originally was, or after one power of appointment.
I understand, but she is the settlor and a trustee.
Yes.
And the trust which she devised through her own counsel is being critiqued here. Maybe some of it's lawful, maybe some of it's unlawful. And I keep thinking, well, where is she? Doesn't she have a right to be here? It's going to affect her very directly. She's not just tangentially interested in this, I assume. It would be of consequence. If she were fully competent, you think we could decide this case and she'd never be in a courtroom?
I don't think her presence matters. I really don't. I'm not sure what she would bring to it. And
Well, she might bring to it. She's the one that created the trust. It's going to affect her intents. And so all we have here are people who are beneficiaries and a trustee who are quibbling among themselves as to who should get what. If the mother were competent, how can we rule on what the trust does or doesn't do? As Justice Duggan said, it may have repercussions for her, and she's not here, not been notified?
I think her presence would be necessary if the trust were being attacked, that she had to defend the existence of the trust. But it's not being attacked.
Does she have a guardian?
It sought to be enforced.
Does she have a guardian?
No. There was a proceeding to appoint one, and that ended in going away.
Well, doesn't she, I guess my problem, Mr. Gordon, doesn't she have a chance to get an oar on the water here? Doesn't she have a chance to get the oar in the water to say, well, I hear what Mr. Gordon's saying, but this is my view of that. I mean, no one's acting in her stead here.
Well, I don't think it's any different than a will or a post-deceased trust dispute where it would be the exact same issues. So I don't greatly see that as a problem. Again, if the trust itself were being attacked, that's fine. But here the trust is, my clients, plaintiffs are asking the trust be enforced.
One of the issues, one of her daughters deeded some real estate to herself and to two siblings. Mom might say that's not what I intended.
Oh, I wish she had the opportunity to testify.
Well, no, but the point is, I'm sure you do, but I'm saying whatever her testimony would be, it seems to me it's her trust. I mean, I don't know, you have to go much further than that. She created the trust. We're going to decide who gets what under her trust. We're not going to tell her she doesn't have a chance to be here.
I've made my reply, Your Honor, and if I have to make a comment on one more issue, Evelyn deeded Lot A to Alan by power of an appointment, and for two reasons, both somewhat complicated, she really can't. A donor creates the power of appointment. A donee exercises it. Here, she exercised it as donor repeatedly, but that really conflates centuries of trust law, and we can fix it by deeming one the other, but it really doesn't exist in trust law.
You lost me there. Can you go back? Why is she a donor there and not acting as a trustee?
Well, there's this power of appointment, which is the ability to determine what happens to your property after death. And the donor of a power of appointment creates the power. The donee is the one who exercises the power, and the appointee is the one who receives enjoys the property that is appointed.
And is there a clause in this trust instrument to that effect?
There is a clause that allows her to make powers of appointment, yes. Okay. But the donee is the one who exercises power in standard trust law. Here she exercised them as donor. It doesn't jive with trust law. It's outside of trust law, and I don't really know what to do with it, but it seems to me it invalidates the conveyance. The second reason is that in New Hampshire, you can't make multiple appointments of the same asset. And the reason for this, and I think New Hampshire is in the small minority of states, is that creditors can reach the interests of both donees and appointees before the death of the donor. I realize that's lots of trust law, but once an appointment is exercised, other people acquire rights, the creditors, which must be respected. And this court applied this rule twice, at least twice, once in 1844 and once in 1954. And so in New Hampshire, I think it's a small minority of states, an asset can only be the subject of appointment once. And here, Evelyn did it again and again and again. That first appointment is probably valid insofar as it complies with the equality clause, but the subsequent ones are not. No more questions. I'll sit down.
Thanks very much.